The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to this remote argument session of the North Carolina Court of Appeals. I'm Judge Richard Dietz, and joining me on the panel this morning are my colleagues Judge Hunter Murphy and Judge Darren Jackson. And we have two cases we'll be hearing this morning. The first one will start now, then we'll have a brief break. And for those watching remotely, there'll be a separate link then to the second argument. Before we begin, I also do want to thank Deputy Supreme Court Marshal Richard Remillard. The calendar in this case and the next case today did not reflect that they would be remote. And when we arrived at the courthouse this morning, Deputy Marshal Remillard was in his uniform and in the courtroom waiting the arrival of the lawyers. So we'd like to thank him for being here and apologize for not notifying the Supreme Court Marshal Service we would be remote today. With that, we'll turn to the first case, number 21-326, Tutterow versus Hall. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
May it please the court, my name is Hank Van Hoy. I am the attorney for the appellant in this case. I appreciate greatly the opportunity as a lawyer to argue before you to help clarify a point of law. It is fun, and it's what lawyers should be about, and thanks for that opportunity. This matter is before you on our appeal from a summary judgment granted in a declaratory judgment action that we brought by Judge Crosswhite, granting summary judgment for the UIM carriers State Farm and Horace Mann, and denying summary judgment for Tutterow. If it would help the court, I would relay a brief statement of facts, but if you are thoroughly familiar with them from the brief, I would just proceed on to the issue, if you would let me know what you think.
Well, I think we'll leave that to your discretion. We are familiar with the facts. We've read the briefs.
All right. Well, I presume that. So there are really, I think, two issues to be resolved in this case. The first has to do with how UIM coverage is calculated when there are multiple underinsured defendants in a case and multiple UIM carriers for each separate case against a negligent defendant. So the question is, do you compare the liability coverage separately of each single at-fault underinsured motorist against the UIM coverage applicable to each separate claim that, in our case, Tutterow had, and in our case, 100,000 of liability to 200,000 of UIM as to each at-fault driver, as we contend, or as State Farm and Horace Mann contend, do you combine the liability limits of each at-fault motorist, in this case Hall and Crump, in the total amount of $200,000 to Tutterow's UIM limits of $200,000, as if UIM applied in the aggregate rather than separately against each tortfeasor. Depending upon how that question is answered, then there is a second issue before you, and that has to do with what is the effect of the failure of Horace Mann and State Farm to advance within the time period that's required under the statute, the 30-day notice. In our case, I would submit that there's no question about the following, that both the Crump and the Hall vehicles were underinsured at-fault motorists, as that term underinsured is defined under the statute. Secondly, that UIM was triggered when each liability carrier tendered its liability limits, and notice was given to the UIM carriers in November of 2016 by me, by a letter that you're familiar with that's attached to the record. It's also clear that the tendering of the full policy limits exhausted those liability policies, and it's also clear and stipulated to that the UIM carriers did not advance within the 30-day time frame, and as a result waived subrogation. These statements.
Let me ask you a foundational question about that. So in Lunsford v. Mills, suppose that, so you've got $1 million liability policy and a $50,000 liability policy, and then 400 in UIM coverage. And, if you read the way that we've described UIM coverage in our case law, and you told someone who wasn't familiar with the statute in our case law that scenario, I think most people's reaction would be say, well, this isn't a UIM case because there's $1 million insurance policy. But we know that's not the case. I think your friends for the appellees are going to agree that this is a case where UIM is triggered, and we're examining separate questions. So my question to you is, suppose in Lunsford that immediately after the accident, both the $50,000 policy and the $1 million policy tendered the full amounts, the full limits of their policies. Is it your position that in Lunsford, there still would have been an obligation for the UIM carriers to also advance their $400,000 UIM coverage?
That is my position. And the reason is that in our case, it's different from Lunsford, is that there are two UIM underinsured motorist vehicles, whereas in Lunsford, there is one underinsured carrier and one vehicle, the $1 million one, Mills, that was not an underinsured carrier. And so if the result in Lunsford had been that all you do is compare the total liability against the total UIM, that would have ended the case. There would have been no need to discuss anything else in Lunsford. That's not what happened.
So suppose in Lunsford that happened. So the UIM carriers advanced $400,000. The $50,000 liability policy tenders $50,000, and the $1 million policy tenders the $1 million. The court in Lunsford said that the UIM carriers can recoup their $400,000 from the $1 million. So how much ultimately does the $1 million policy pay? Does it pay out $1 million to the injured party and then also pay $400,000 to the UIM carriers?
In Lunsford, of course, the UIM carrier did not advance. So let's assume, if I'm understanding your question
yes, this
correctly,
is hypothetical. I've changed the facts from Lunsford.
That when Buchanan's liability carrier tendered the $50,000, that Farm Bureau in that case did what it was supposed to and advanced $350, not $400, because it gets credit for the $50 under the statute. Then liability was paid by whatever amount, the full $1 million, or in Lunsford, $850. In that event, Farm Bureau could have recovered the excess payment. But in our case, there is no excess liability. There was excess liability in Lunsford by the difference between what the UIM coverage was and the liability coverage. In our case, that's not what happened. The UIM, the liability policies of 100 each, compared to the 200 of UIM coverage. The UIM carriers get the $100,000 credit, but they have to pay the UIM coverage. There is no excess insurance coverage as there was in Lunsford.
But you see where I'm headed with my questions, what I'm trying to understand is if they're entitled to the recoupment of the UIM covers that they advanced, then isn't it the case that in Lunsford, our Supreme Court understood that those were that you considered the policies collectively in assessing that? In other words, you can't ignore the fact in deciding how much coverage applies under the UIM policy. You can ignore this other $1 million policy and only consider the $50,000 policy. They must have, because otherwise, how could you recoup that payment and reduce the amount that the $1 million policy would ultimately pay to the party?
Well, suppose that what the other insurance carrier was an underinsured carrier rather than a liability carrier. Then there would have been no recoupment because there was nothing to recover from, which is the same thing in our case. When you consider, as we would say correctly, the UIM coverage against the liability coverage, the difference between this and Lunsford is that though in Lunsford, assuming the UIM carrier had advanced, there was money against which the UIM carrier could have recovered. That's not the case in Lunsford. So even when you consider them both, you don't come out mathematically that there's anything for the UIM carriers to recover from had if the statute had been properly applied in our case. Again, the difference in Lunsford is that there is this excess money from which the insurance carrier, the UIM carrier, could recoup. And so it's proper for the court to say you could have gotten that.
Going back to my first hypothetical then, so your position is if the $1 million policy immediately tendered and the $50,000 policy immediately tendered, your position is that the UIM carriers would still also be obligated to tender the 400,000 minus 50, the 350,000. All that money would be tendered, and then, how are you getting it back? You seem to have immediately given the windfall that is the one thing we're trying to avoid in interpreting these statutes, and that's what I'm trying to understand because my hypothetical could happen under your interpretation, and I'm trying to figure out how we would address that.
Well, again, if all that happened simultaneously, as your hypothetical proposes, then it's quite clear that you'd apply if the UIM carrier advanced or said it would advance, and you've got the liability, you just apply the math to it. In our case,
so wait, when you say apply the math to it, what do you mean by that?
I mean that because there was excess coverage in Lunsford, there is money from which the UIM carrier could recoup. And so if you had the two occurring simultaneously, it would be obvious that you could recoup that if the UIM carrier said, okay, I'll advance, but you work out the settlement and you don't have to go through the math. But if you did, let's just say that they followed the statute and the UIM carrier advances, and then the liability carrier for Lunsford, the uninsured liability carrier pays, then the way that would work is that the UIM carrier would get paid back the 350, not 400, because it got credit for the 50. In our case, the windfall falls to the UIM carrier, because if you had one single at fault tortfeasor, one underinsured motor vehicle, 100,000 with two UIM carrier would have paid 100. What they're saying is, then the more tortfeasors there are, you forget about the UIM coverage applicable to each tortfeasor, and they pay nothing, which is a windfall to the UIM carrier.
Mr. Van Hoy, just so I want to make sure I understand the arguments you're making and the arguments in your brief a little bit better. Is it your position that although the result may be a windfall to the injured party, it's not an uncontemplated and unlawful windfall because of the way the statutes and the General Assembly has expressed that desire and expressed that decision making?
I wouldn't phrase it that way at all. I don't think there is any windfall to the injured party, Tutterow. In this case, as we noted in our demand letter to them, we believe is worth $1 million. She gets 200 the way it's calculated by the UIM carriers, 100 of liability and 100 of liability and no UIM. The only windfall there is, the way the statute would read and the way I believe the case law reads, falls in that case to the UIM carriers, not to the underinsured.
And maybe windfall is not the best phrase in it. And due to the delay, your client is entitled to this extra amount under the statute. Not necessarily that it's a windfall, but that was a decision by the General Assembly. Or maybe I'm completely misreading the briefs and misreading your argument. And given where, I just got reversed in Dana a few weeks ago, maybe my understanding of UIM is a little bit garbled at this point.
I think Lunsford answers the question as you just put it correctly. The UIM carrier didn't advance on the $50,000 liability claim. And so in the Deck J that followed, the plaintiff offered the credit that the statute allows for the $50,000, and the UIM carrier then was found to have to pay the $350,000. And because it did not advance, just as it did not, neither of them advanced in our case, timely, then the court said you can't recoup because you waived your rights of subrogation. You waived your right to recoup. And the court specifically said recovering that $850,000 of liability plus the liability insurance for the uninsured vehicle, Mills, plus the 50 from the Buchanan vehicle, plus the 350 of the UIM was not a windfall to the injured party.
But
Our
in
case,
Lunsford, let me just make sure I understand the facts. Had the $1 million policy tendered?
no.
So, I mean, isn't that a critical that's the part that I'm getting at is if they had. So if the injured party has right now a $50,000 payment and let's say $1 million, and then there's the question of whether the UIM carriers need to come in with their money. The argument would be, well, you can do the calculation now and determine that the amount they owe is nothing. So there's no obligation to tender anything. I think that's the argument your friend for the appellees are going to make. And
that is the argument. I'm sorry, I didn't mean
go ahead.
to interrupt. That is the argument they make, and it's mathematically wrong. Again, the argument they make simply is, and put it the facts the way you say, is that there is no UIM coverage because you aggregate the two liability policies. But that's not what Lunsford did. Lunsford, had they been tendered at the same time, what would have happened is Lunsford would have been obligated to pay its $350, and then it would have gotten credit and been able to recoup from the UIM carrier, the uninsured carrier, from Mills. Out of the $850 that Mills got its payment. It did not advance, so it didn't do that. Same thing in our case. What the court didn't do is to say what the appellees say is, well, there's 50 of liability, $1 million of liability, that exceeds the aggregate of 400 of UIM, and therefore no UIM coverage. Court could have said that simply. It did not say that. And the reason it didn't is because, like in our case, when you calculate the UIM coverage and the liability coverage separately to each motor vehicle, as you are supposed to do, and to each claim, single claim, as you're supposed to do under the limiting statute, you don't have any excess coverage against which to apply. The claim against Crump was 100,000 liability, 200 of UIM. 100 was owed, nothing to recover from had they advanced. The same with Paul, 100 of liability, 200 of UIM. One of the insurance companies gets the credit, but you still wind up with them having to pay 100 of UIM in each case, and there is no money, as there was in Lunsford, to recover from.
So the reason I'm asking so much about Lunsford is, so I want to move you along because I know we're getting in your time, is there's a provision in the statute that to me seems to answer this question unless our case law is interpreted in a way other than the way it's written. So can we talk about this language that says, if a claimant is an insured under the underinsured motorist coverage on separate or additional policies, the limit of underinsured motorist coverage applicable to the claimant is the difference between the amount paid to the claimant under the exhausted liability policy or policies, plural, and the total limits of the claimant's underinsured motorist coverages, plural, as determined by combining the highest limits under each policy. So I'm wondering why it's worded that way if the interpretation we have to use is the one you're advancing right now. Why did they use that? Why did they say exhausted liability policy or policies and then refer to the underinsured motorist coverages?
I can explain that. If this is when I'd like for Mr. Hawk to put the exhibit up that has that language. All right. So this is the limiting and measure section. Remember that for the way the statute, well, I'll come to that. It reads, in any event, the limit of underinsurance motorist coverage applicable to any claim, that's singular, not plural, is determined by the difference between the amount paid to the claimant under the exhausted limited policy, liability policy, or policies, and the limit of underinsured motorist coverage applicable to the motor vehicle involved in the accident. Single claim, single motor vehicle. Then the furthermore language, contrary to what the UIM carriers say, the furthermore and the use of that word furthermore is referring back to a single claim and tells you how you calculate the measure when there are more UIM policies applicable to a single claim, not multiple claims. And that's where the misreading, I believe, comes. So if the claimant is insured under the insured motorist coverage on separate or additional policies, the limit of underinsured motorist coverage applicable to the claimant is the difference between, that's where you have the aggregation language. But I submit to you that what that language is saying is that that explains for a single claim, the prior sentence, what happens when there are multiple UIM coverages applicable to that claim, not to aggregate them against all claims. Nowhere in that statute do you see the plural vehicles. And that last sentence, the uninsured motorist limits applicable to any one motor vehicle under a policy shall not be combined with or added to the limits applicable to any other motor vehicle policy. So it's incongruous, I submit to you, that when you read the statute together, that you define underinsured vehicle in the singular, you define triggering in the singular, you define exhaustion in the singular, and then you refer to any claim applicable to any one motor vehicle, and then read into it a plural to vehicles or multiple claims that the statute doesn't say. That's not how you read it, and Dana would suggest that you read the statute in the manner appropriate to provide the victim the fullest coverage. Not all the coverage it could get, but the fullest coverage to protect the victim. That's the only way you can do it, other than to give the UIM carrier the benefit of the saying that if you aggregate it all, we don't have to pay, whereas they would have paid if there was only one claim. That makes no sense in reading the statute in that way. The statute, there's nothing in our law that says you read the statute to give the UIM carriers a benefit. And the fact that their policies say differently, the statute controls over differences in the policy.
Mr. Van Hoy, you would agree that there was only one auto accident involved in this?
Agree that there's only one auto accident. Yes, sir.
And in a lot of places in the policy, it refers to the same accident. And so this is one accident, correct?
That's correct.
Okay. So let's say that there had, in my hypothetical, there had been 5 cars involved, and this had been, a big pileup, and there was a fatality, and so everyone got sued. Is it your position that Forest Man or whoever could have had a potential underinsured motorist on coverage claim for each car that was involved in that accident, in that they may have written $100,000 underinsured policy, but they may have been on the hook for 5 cars that each were underinsured for a total of 5 different claims? If a great plaintiff's lawyer like yourself was able to get each of the other vehicles to pay their full liability limits?
It is my position that the UIM coverage applies to each underinsured negligent defendant. And the effort to obscure that by the way they write per accident is nowhere to be found in the statute. The statute doesn't read that way. And so I don't blame the UIM carriers for attempting to limit their liability. But when a customer goes and buys a policy that says, I have UIM coverage for an underinsured vehicle, they believe that's what that means. And that's what the statute says. It's the language to the contrary in the policy doesn't apply. That we don't have anything in our law that says to the contrary, in my opinion.
Thank you.
So in Dana, and in many of our other cases that have dealt with this statute, we've said there's an ambiguity. And that's why we get into what was the purpose, and then we can use that to try to interpret the words that are ambiguous in a way that achieves what we think are the legislature's policy goals. We ultimately think that the provision that you just had up on the screen that begins with the word furthermore is not ambiguous. If we think that it provides a clear answer, even if we're not certain that it's the one the legislature intended, we would follow the plain language. Would you agree with that? So because we can't say, well, other parts of the statute are ambiguous and we've had a pro injured party interpretation. We took a favorable interpretation, but so we should do it to all the rest of it, even the parts that aren't ambiguous. Would you agree with me about that?
I agree that, as you've stated and as Lunsford said, if the language is unambiguous, you have to apply the language. I think that's what the case law says, and of course that makes perfect sense. I don't believe in this case that that language is unambiguous. I think it is ambiguous, and I think that's what Lunsford says that it was, and that's what Dana said, is that the language of the statute is ambiguous, and you've got to interpret in Dana in a way that, in essence, that hybrid formula, and I think the correct term is common sense formula. The way
you agree that Dana didn't interpret this particular provision.
I agree with that, but Dana was
even
interpreting
Lunsford didn't address this particular provision.
I agree with that.
So this appears to be the first time we're called upon to ask, is this language, and I'll acknowledge to you, we keep having to address different portions of the statute and keep having to say it's ambiguous. It does make you wonder why the legislature doesn't just rewrite this provision and remove all the ambiguities. But I just wanted to establish for you that you would agree, if we don't think there's an ambiguity, we're just using the language that's been chosen by the legislature.
I believe that's correct.
All right. Well, we've eaten a little bit into your rebuttal time, so we'll give you some extra time. If you don't have anything further, I'll let you reserve the remaining time.
All right. Thank you, Your Honors.
Thank you, counsel. We'll hear from the appellees.
Yes, may it please the court, Your Honors. My name is Jeff Kuykendall. I'm attorney for Appellee State Farm. I will try and argue for the first 15 minutes approximately, and then my colleague, Ms. Boardman, who is attorney for Appellee Horace Mann, will argue for the final 15 minutes. I sort of want to jump right in, Your Honor, Judge Dietz, to where you started with your questioning, which is the Lunsford versus Mills. I think, at least as I understood your questions, you've gotten right at the heart of the issue with how Lunsford and the Supreme Court has, in essence, adopted what appellees are arguing here. Your hypothetical is an excellent one in that in that case, if both parties had tendered at the same time, Mills and Crowder, or Mills and Buchanan, what Mr. Van Hoy's position is you'd have to pay that $350,000 of UIM regardless. His position is even if they both tendered at the same time, like they did in this case, he'd still hit that injured party would still be entitled to the $350,000. The problem with that argument is that in Lunsford, the Supreme Court takes great pains to talk about the process of how to recover an overpayment if a payment is made. If that money is owed under the Financial Responsibility Act and under Lunsford, there is no way to recover it. It doesn't matter when you pay, how you pay, or anything of that nature. If you compare the UIM stacked limits to the liability limits separately, as appellant is contending, then there is no way to recover it because that $350,000 would have been owed. And Lunsford is very clear that there is a way to recover it. So it wouldn't have been an overpayment. It would have been a payment that was just owed. And Lunsford and the court would not have gone into all that. So I think that is a key piece of this. Mr. Van Hoy also talked about sort of this windfall, and Mr. Van Hoy described the windfall as Ms. Tutterow being very injured. The windfall analysis you have to look at as the UIM that was purchased was for $100,000 on each of the State Farm and the Horace Mann policies. No dispute that those policies are stacked under North Carolina law to a total of $200,000, but that's what Ms. Tutterow got, was $200,000. Anything above what was purchased is the windfall. That is the argument. It is not that she is entitled to get compensated for her bad injuries. It's that she's entitled to get what she purchased or what was purchased that she can take advantage of. And that was a total of $200,000 between the two policies. And that's exactly what was tendered back in 2016 and could have been accepted shortly thereafter. The only reason it wasn't paid back then was a decision they made to continue to seek other monies. So I think Lunsford versus Mills is very clear in that, in giving guidance on this very question, that if there's going to be an overpayment, if the court's going to describe it as an overpayment, it means you don't look at them separately. You don't compare the stacked limits to $50,000 and then separately the stacked limits to the $1 million policy.
So why in Lunsford, why did they not consider the $1 million policy in Lunsford? Is it because there were questions about whether there was coverage under that policy?
No, I think it's because that $1 million policy was not tendered. They ended up only paying $850,000 of that policy. There was no belief that the full amount of the policy was due and owed. It was not tendered at the beginning. So if it had been tendered, then they would have considered it. But it was not tendered. It was ultimately paid. A smaller portion of it was paid at a later date. So that's the answer to that.
I guess my question is why does, when reading Lunsford and looking at the language in the statute, why is tendering it so important? That's my question.
Sure, and this gets into a side issue in this case. So the reason tendering is so important is because this court in Daughtry versus Castleberry and some other cases has said that tendering is the act that exhausts the liability policy. It is, even though the statute uses the word paid, the tendering is determined to be the payment that exhausts it. So once you tender, you have then exhausted that liability policy. And in this case, when both liability policies were tendered for the Hall defendants and Crump, both were exhausted around the same time. So there wasn't, unlike Lunsford, where it's this staggering where you tender one and then you have an obligation to make up the UIM difference and then tender another one later. You don't have that here. They were both exhausted at the same time. This is sort of where I launch into what State Farm did many months or years later. Was it advanced the $100,000 once the Crump money was actually accepted. And it did that because the statute says when the money is paid. So even though there's this case law out there, State Farm in an abundance of caution said, okay, one of the policies has been paid, so we will advance our $100,000, which is the difference between the stacked UIM and the amount that was paid, so that we're protected under Lunsford versus Mills. So if they're exhausted back when they're tendered, there was no UIM left to be paid. If this court goes a different way and says, well, paid actually means when the money is accepted, then State Farm advanced that money and there's no, and it gets to get reimbursed for that $100,000 once Tutterow accepted the amount from the Hall defendants. And Your Honor, Judge Dietz, again, you pointed to the precise language in the Financial Responsibility Act that is at issue and highlighted the exact parts that we need to examine. The sentence that you read, the furthermore sentence, makes it incredibly clear, and it is not ambiguous, that if a claimant is insured under the underinsured motorist coverage on separate or additional policies, which Ms. Tutterow was under the State Farm and the Horace Mann policies, the limit of underinsured motorist coverage applicable to the claimant, singular, Ms. Tutterow, is the difference between two amounts. First is the amount paid to the claimant under the exhausted liability policy or policies. So the statute expressly contemplates multiple liability policies, just like we have here. So that number, I don't think there's a dispute, is $200,000. 100 from Crump with Horace Mann, and 100,000 from the Hall defendants with Nationwide. So you then compare that, or to find the difference between that amount and the total limits of the claimant's underinsured motorist coverages, which again is not in dispute. That's 200,000, 100,000 from State Farm, and 100,000 from Horace Mann. So the difference between 200,000 and 200,000 is obviously zero. So none is owed once the liability policies are exhausted. And they were
your argument. Your friend for the appellant says if you have to read this language in context with the language in the that precedes it, and when you do, this language is talking about there's essentially an implied indication that this is about coverage of a particular motor vehicle. So you can't, or at least that's what I understood their argument to be. So what you're doing is you're combining these policies, and you can't do that. You have to look individually at them, and if you do that, then you and then apply this plain language, then the money would be owed. So doesn't that, it seems to me like a reasonable interpretation. And if it is reasonable, even if we think it might be wrong, it means there's an ambiguity, and then we get into the Dana analysis of what is the policy goal here. So what's your response to that?
Okay, several things. And with all due respect to Mr. Van Hoy, I disagree with his reading of that the sentence before this somehow implies that this sentence doesn't mean what it says it does. Any implied meaning of the sentence before does not overcome the express language in this sentence. There is only one claimant. This is not a situation in which there was Ms. Tutterow and a different claimant making two different claims. That would be a totally different analysis. This is one claim by one claimant. The claim is, I was injured in this single accident or this single sequence, and I am entitled to this money. There is also the issue of whether UIM follows the person or the vehicle that we've talked about in the brief. And then finally, the statute, the plain language of the statute contemplating this precise situation, which is the previous sentence dealt with a situation where there might not be multiple policies. This one dealt with if a claimant is insured underinsured motorist coverage on separate or additional policies. So it's contemplating a different scenario. The legislature is, here's one scenario, and now we go to the second sentence saying when there are multiple underinsured motorists, here's how you handle it. So they're related, but they are two different scenarios that the legislature is examining. And finally, in the Dana scenario that you were talking about, I would point out that in Dana, I think it was Justice Berger, who talked about that even if you find some ambiguity in the Financial Responsibility Act, part of the obligation is to then look at the policy, because the Financial Responsibility Act is read into the policy. If there's an ambiguity, that doesn't necessarily mean we throw it all out, but we can also then look at the policy to find out what the policy has to say about these situations. And the State Farm policy, and I think it's the Horace Mann policy as well, is very clear that the most the underinsured motorist coverage will pay for bodily injury is the limits, regardless of the number of insureds, claims made, vehicles involved, or anything like that. And the policy includes a reduction clause, which makes it very clear that the amount paid UIM is reduced by the liability policies. And that reduction clause has been found to be unambiguous. And we cited to the Davidson versus United States Fidelity case, the Harrington versus Stevens case. So there are a number of cases that find that portion of the policy is not ambiguous.
So let me ask real quick, just talking about Justice Berger's reasoning there in Dana. if I'm not mistaken, although it was a concurrence, none of that Justice Berger's language is binding on us, was not made part of the majority or adopted by the majority, correct?
I agree. It was a concurrence.
I just want to make sure none of that reasoning was pulled into Dana or anything like that. Thank you, sir.
Yeah. And the other thing I would add to Justice Jackson's question about the 5-car accident, if appellant position is correct that you have to evaluate UIM separately, then he's got to say, yeah, if you have 5-car or 20-car or 50-car, you got to compare the UIM to each one separately, every single one of them separately, and talk about windfalls. You're ending up with someone getting something well beyond what they purchased, well beyond what was bargained for. And, Ms. Tutterow or anyone else who's purchasing UIM has the option to select the amount of coverage they want. And Ms. Tutterow got $200,000 worth of coverage, whether that's from liability policies, underinsured motorist coverages, or whatever. She got what she paid for. Anything beyond that is the definition of a windfall. Now, finally, on to this. I'm sorry.
Real quick, does the delay factor into whether something is actually a windfall? If the delay would allow for greater recovery under the statute, is that still a windfall?
If the delay would, you mean like in lump
delay in
sum?
tendering?
I'm sorry?
The delay in tendering.
If you mean
if that's contemplated by the policy that this delay, even if it results in a windfall, well, that's not really a windfall. It's just what's contemplated by the statute for any delay that may arise in the tendering process.
If I'm understanding you correctly, if in our case, one of the like Horace Mann had tendered its liability policy and Nationwide had not, the UIM carriers would have then had an obligation under Lunsford versus Mills to pay $100,000. And if they failed to do that, they failed to advance it, then Ms. Tutterow would have gotten to take advantage of that fact. But if they had advanced it, they would have gotten to recoup it. So the delay doesn't create a windfall. The delay is saying to UIM carriers, you can't just sit back and say you have to pursue any and all liability sources. It's saying once you've received one of them or been tendered one of them, UIM then kicks in. So that's not a windfall question. That's just to keep the insurance companies from taking advantage of an insured and saying, now you got to file a social host liability or something like that. So I don't want to eat into Ms. Boardman's time, so I am going to leave her with slightly less than I promised. Thank you, Your Honors.
May it please the court, Kara Boardman on behalf of FLE Horace Mann. I do want to start by addressing a fact related to the Lunsford matter that has been addressed but not really specified. In discussing the factual basis for that opinion, the numbers that have been discussed are the fact that the underinsured motorist coverage should have been advanced in the amount of $350,000. When applying the $350,000, that doesn't take into consideration the fact that that involves a credit for the $50,000. The total UIM in that case was actually $400,000. So even under Lunsford v. Mills, the court is recognizing that there is a credit or reduction of the applicable UIM coverage in that case, regardless of advancement, regardless of whether or not they made that payment when there was the initial tender of the $50,000. They recognize that that $50,000 should be offset and reduced from the overall UIM limits. This is something that Mr. Van Hoy addressed in his argument, and he didn't say they should have paid the $400,000. He said the $350,000 is what they should have paid. Same applies in this case. Because the tender in this case was the $100,000 from each of the liability carriers, which we argue should be combined to be $200,000, that initial $100,000 should be credited to Horace Mann in this case as the primary UIM carrier. The minute that tender occurred in November of 2016, there's no further obligation to advance due to that credit and reduction under the Financial Responsibility Act and under the terms of the policy. It's similar to Lunsford in that regard, and I think it's important to address that $50,000 is what's comparable and applicable in this case to the initial $100,000 that was tendered and eventually accepted by Tutterow in this matter. The reduction clause is especially important because it's not really addressed in the appellant's initial argument. That's an essential part of the Financial Responsibility Act and the second clause of how we are applying what UIM is actually available. Given what was in the briefs, I think it's been pretty widely explained by both myself and Mr. Kuykendall, but I think in this instance, it's important to address the fact that it's the combination of the two. And there's not been any case law indicating that the liability policies cannot be combined and that they're not entitled to an offset or credit from that initially. It does not create any obligation to advance beyond the amount that there's actual coverage for when you look at what the UIM limits are in this case. I did touch on briefly that we believe that Horace Mann coverage would be primary. So that first $100,000 would apply, meaning that Horace Mann would not have an obligation to make any advancement under their policy language and under the Financial Responsibility Act. As previously addressed, I think some of the ways that it has been interpreted that this is supposed to be applied on a per accident or per vehicle basis just simply isn't accurate. We look at the case law, and there's numerous cases cited in all of the briefs that indicate that the UIM coverage in this case should follow the person. We're looking at the individual claimant. We're looking at Tutterow in this case. And the applicable policy has to be applied under the terms of the Financial Responsibility Act, which does foresee and consider whether or not the policy or policies applies. And it's important in the statutory construction to give meaning to when there is a plural or a singular and where those words relate to each other.
But Dana didn't give any meaning to the singular and the plural, right? So I mean, until I read Dana, I would have 100% agreed with you. I think plural and singular is really important in statutory analysis, but our Supreme Court didn't think so.
And I think Dana does address that to some degree because they look at the interpretation of the word limit or limits. And in doing so in Dana, I think that their interpretation looks at the plain meaning of the words in the application in terms of what this applies to. Obviously looking at insurance policies and how those coverages are addressed. And looking at the word limit or limits applying to either a per person or per accident is really the focus in Dana. And I think it was properly applied when looking at the context. And the fact that limits here are key in an issue, I think Dana is instructive on how we should address this. So additionally, I would think that in treating someone differently, the purpose of the Financial Responsibility Act is to put someone in the same position as they would have been if the vehicles that had been involved in this accident had either the same liability limits as the UIM or were an uninsured motorist coverage. It's not to create any additional coverage under uninsured motorists over and above what was bargained for and if the vehicle had been contextualized as either of those other two categories. In this case, what the plaintiff appellants are arguing for is whether or not, in this case, they'd be entitled to an amount over and above both what was contracted for and what they would have received had the other vehicles involved in the situation had, in fact, been either uninsured or had liability limits equal to the uninsured motorist coverage. In this case, the uninsured motorist coverage totals $200,000. Any amount over that does not put them in the same position under the Financial Responsibility Act that they would have been otherwise. That's the same premise that they support in Dana in the recent opinion, that they don't want to provide an amount over and above, such as a windfall or any other kind of punitive measure to put any emphasis on the insurance company to pay more than was contracted for. The goal is not simply to provide protection, but to provide the same protection. And that's something that I think that gets overlooked in plaintiff's argument, that they're trying to put them in a position over and above what was contracted for under the UIM policy. Additionally, I think there's a separate issue that hasn't been addressed very thoroughly at this point as to the advancement versus subrogation rights. We say that this is inapplicable in this case. We're not talking about subrogation, right to recover against a third party. We're talking about whether or not there is a credit or offset that they're entitled to under the basic analysis in terms of determining the UIM coverage. There's no subrogation issue in this case. The issue is one of whether or not there's a credit or offset based on the liability limits compared to the applicable underinsured coverage limits. And in that case, we don't believe that there is any issue regarding subrogation. The waiver of subrogation is not an issue.
Just so I'm fairly certain I understand your argument, but your argument here is the limits under the statute that apply are the difference between you say the difference between 200,000, it's 200,000 minus 200,000, which equals zero. So you're saying
Yes.
the limits are zero, meaning there's no, you pay nothing because zero means you're already at the limit. And
Yes.
is that essentially the argument you're making?
That's essentially the argument, and that there be no reason to advance, and there's no issue with subrogation because there is no coverage under UIM in this case because the liability equals the total amount of the UIM. The idea that
So
subrogation
the UIM's triggered,
Yeah.
it's just you're already at the policy limits.
Exactly. So it's that two-pronged approach that one, to determine if it's an underinsured vehicle, and then the next step is to determine what the amount of coverage is. Just because it's an underinsured vehicle does not mean that there is going to necessarily be additional coverage over and above the liability limits when all liability policies are considered under the statute. And based on the fact, we don't think there's any issue regarding the waiver of subrogation. We think that in this case, the underinsured coverage is both appropriately responded when the calculations were made, the tenders were made in this case. Because there wasn't a tender in Lunsford, because there wasn't the total amount at issue, we don't believe that this is going to be a case that's the same factual scenario as the other matter. We look at, there's numerous other cases that we've cited in which credits have been addressed and allowed before any advancement. There's several of those, including the Benton case, Harrington, as Mr. Kuykendall addressed. Additionally, I think it's important to note that even in Dana, they talked about a proposed distribution. They don't talk about payments, but the proposed distribution or the offer of payment that would exhaust or tender the policy was sufficient in Dana for the court to address whether or not the UIM, the amount of UIM that would be available under those policies. There doesn't have to be payment or an additional acceptance under the policy for there to be that exhaustion. Additionally, I think that there are a few other points regarding the statutory construction and the idea that there would be some kind of emphasis about any delay that might be offered in this case. There is no issue regarding delay because if there's no coverage, there's no delay in providing any payment because that determination is made when the tender occurred. So there was the only option in this case was left to the plaintiffs themselves to whether or not they wanted to pursue coverage from any additional sources. That did not change the amount of the tender or any exposure on behalf of the UIM carriers. Therefore, there was no prejudice or damages caused by them not advancing since there was nothing owed under the issues in the case. And at this point, I don't have any further arguments. I'd cede my time to the panel if there's any questions.
All right, thank you, counsel. I think we understand your arguments.
At this time, we just asked for an affirmation of the trial court's decision on the summary judgment.
All right, thank you, counsel. Any rebuttal?
The arguments that I've just heard just don't follow what the limiting language section says. The limiting language section provides that any claim is determined to be the difference. A claim is personal. That's not dealing with the motor vehicle. Claim, in this case, there are two. There's one accident, but there are two claims. And each one gets the benefit of the UIM coverage. There is no case law that aggregates liability against all UIM coverage. As I've indicated, when they say that I'm arguing per motor vehicle, that's not the case. The reference to, in the limiting language in the first sentence, to a motor vehicle has to do with the liability limits applied to the underinsured motorist vehicle involved in the accident. And then that is the claim against the motorist vehicle. And that's singular. And the furthermore language explains, as I've argued, that that's telling you how you calculate per claim the applicable UIM coverage. Secondly, the issue of the credit is the trial court did not resolve the credit because it didn't answer the first question in the way that you would get to the credit. But Lunsford the plaintiff applied the credit that goes against the policy. You measure 100 of liability in our case against 200 of UIM per claim. The same in Lunsford. One claim with UIM, you measured, the plaintiff conceded it, $50,000 liability against the 400 of UIM 350. But the court did not do what the plaintiffs, or rather what the appellees claim, and aggregate the two. Had they done that, there would have been nothing else to do other than for the court to say that. And the Lunsford case is really important about the failure to advance. They can call it overpayment, recoupment, subrogation, or whatever. What Lunsford says is that if the UIM carrier is obligated to advance, and when it fails to do so, then you can call it recoupment or whatever. But when that happens, because the $50,000 was credited, they don't get that again from the Mills carrier. What the appellees argue is that they get, or are attempting to get, a credit twice, which we briefed thoroughly, and I won't go back to that point. What we contend is that this matter should be sent back to the trial court to enter an order saying that you calculate underinsured motorist coverage for a claim against the liability of a claim, which would be 200 versus 100. So our client would recover 100 of liability and 100 of UIM on each claim, and that the trial court should also resolve as between Horace Mann and State Farm who gets the credit. The court didn't consider that. Kara argues that it's Horace Mann who gets it, but their policies have that similar language, so it may be that the credit should be prorated. Either way, we don't care who gets the credit. That's just simply the way you calculate the amount of UIM. And the UIM should be 100 per claim, so that the total recovery for Tutterow should be 100 of liability for Crump, 100 of liability for Hall, 100 of UIM for Crump, and 100 UIM for Crump, a total of 400. Thank you so much.
All right, thank you, counsel. We appreciate your arguments, and we appreciate you being here remotely. With that, we will adjourn this session and return to a session at 10:45 for the second argument. Mr. Soar?
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned.
All right, and this is, I say this is it's like virtually walking out of the courtroom. You can drop off now at any time. Thank you, counsel.
Thank you.
Thank you very much.